You filed the accommodation request. You followed the process. Maybe it took longer than it should have. Maybe HR asked more questions than felt comfortable. But you did everything right. And then something changed. Maybe your manager suddenly started documenting every small mistake. Maybe you got passed over for a project you were already involved in. Maybe the schedule that used to work fine became inflexible overnight. Maybe people stopped including you in things. Maybe you're not sure if what's happening is real, or if you're imagining it. You're not imagining it. And today, we're going to talk about what retaliation actually looks like, how to prove it, and what your options are, including options you can take while you're still employed. I'm Drew. This is Disability.co. Retaliation under the ADA is legally defined as an adverse action taken against an employee because they engaged in a protected activity. Requesting a reasonable accommodation is a protected activity. So is complaining about disability discrimination, filing an EEOC charge, or participating in an investigation. If your employer takes action against you because you did any of those things, that is retaliation, and it is illegal under federal law. Updated stat: nearly half of all charges filed with the EEOC include a retaliation component, making it the #1 basis of discrimination charged at the federal level. EEOC FY 2024 data. Here's where people get confused. Retaliation doesn't have to look like being fired. The legal standard is whether the action would discourage a reasonable person from engaging in protected activity. That standard covers a lot of territory. Obvious forms: termination, demotion, pay cuts, removal of responsibilities, negative performance reviews that didn't exist before. But also, being excluded from meetings, having your schedule changed in ways that affect your accommodation, being reassigned to a less desirable location, being subjected to increased scrutiny, being frozen out socially by management. All of these can constitute retaliation if they follow protected activity and are connected to it. The subtler forms are the ones that are hardest to recognize in the moment and hardest to prove later. Increased scrutiny is one of the most common. Suddenly, every small mistake is documented. Standards are applied more strictly. Performance expectations shift upward without explanation. Isolation is another. Being left off email threads, excluded from informal conversations, not invited to events that you'd normally attend. Schedule manipulation. A previously flexible arrangement becoming suddenly rigid right after the accommodation request. Hostility from management that didn't exist before. Tone changes, shorter responses, less engagement. The most important factor in identifying retaliation is timing. Courts and the EEOC look at what's called temporal proximity, the closeness in time between the protected activity and the adverse action. If your performance reviews were fine before your accommodation request and suddenly became negative after it, that sequence matters. It's not proof by itself, but it's significant. The tighter the timeline, the more it speaks for itself. Keep a personal log from the moment you submit an accommodation request. Date, time, what happened, who was involved, what was said. This log does not go on work systems. It goes in a personal document, a personal email to yourself, or a personal notebook. If something becomes a legal matter later, contemporaneous personal records are valuable evidence. One thing worth understanding: employers know that overt retaliation is illegal. Most retaliation in practice is not someone saying, "I'm punishing you for requesting an accommodation." It's a series of small actions, each of which has a plausible alternative explanation, that together form a pattern. That's why documentation, which we'll cover in detail in the next chapter, is the foundation of any retaliation claim. Documentation is the difference between a retaliation claim that goes somewhere and one that doesn't. Because retaliation often happens through a pattern of small actions, rather than one clear event, the record you build, before you've talked to a lawyer, before you filed anything becomes the foundation of everything that follows. Start with the baseline. Before you document what changed, you need to document what existed before the accommodation request. Performance reviews, emails from your manager, recognition you received, projects you were part of. If you have access to this in your personal records or your personal email, preserve it. This is your before picture. Then document the after. Every incident that feels off, log it. Date, time, location, who was present, what was said or done, what the context was. Keep the entries factual and specific, not "my manager was rude," but "on Tuesday, March 4th, my manager interrupted my presentation in the team meeting and said in front of the group that my work wasn't meeting expectations." 180 days, standard EEOC deadline, extended to 300 days in most states with their own anti-discrimination agency. Preserve everything in writing. If you have a verbal conversation with your manager about something that concerns you, follow it up with an email summarizing what was discussed. Forward relevant work emails to your personal email address, where your employer cannot access them. If your company has a policy against this, you can still write detailed contemporaneous notes about the content of those emails. If you make an internal complaint to HR about retaliation, do it in writing. An email is better than a verbal conversation because it creates a record. Keep a copy of whatever you submit. Note the date and who it was sent to. One important point: filing an internal HR complaint is itself a protected activity, which means that if your employer retaliates against you for making an HR complaint about retaliation, that additional retaliation is also illegal. Keep all of your personal documentation somewhere your employer cannot access: a personal Google Drive, a personal email account, a physical notebook at home. Do not store it on work devices or work systems. If your employment ends, access to those systems ends with it. Before you file anything externally, you have internal options, and using them, or attempting to use them, is often important both practically and legally. Legally, because some courts have found that failure to use available internal remedies can complicate certain claims. Practically, because internal processes occasionally work, and because going through them creates additional documentation of the employer's response. Lower third, reviewing your employee handbook. Start with your employee handbook. Most employers of any size have a non-retaliation policy, a discrimination complaint procedure, or both. Read it carefully. Note the timelines it specifies, the person or office it directs you to, and what the process looks like. Following the stated process and documenting that you did matters. Lower third, HR complaints, what to include. When you file an internal HR complaint, be specific. Name the protected activity, your accommodation request or discrimination complaint. Name the adverse actions that followed. Name the approximate dates. Name the people involved. Use the word retaliation if that is what you believe occurred, not because it's a magic word, but because it puts the employer on clear legal notice of what you're alleging. Do not editorialize. State what happened, when, and who was involved. Let the facts carry the weight. Person carefully drafting a complaint email. Deliberate language, specific details. Reading it back before sending. If your company has an employee assistance program or an ombudsperson, those are additional internal channels worth knowing about. An EAP can sometimes provide confidential guidance. An ombudsperson, in organizations that have one, can provide an informal, confidential channel for raising concerns. Lower third, requesting a transfer. In some situations, requesting a transfer to a different manager or department is worth considering, particularly if the retaliation is coming primarily from one supervisor. A transfer doesn't resolve the underlying retaliation legally, but it can provide immediate relief while you decide how to proceed. If you request a transfer and it's denied without explanation, That denial is part of your documentation. After any significant conversation with HR or management about your complaint, send a follow-up email summarizing what was discussed. Their correction or silence is also part of the record. One thing worth saying clearly: internal HR is not your advocate. HR exists to protect the company, not the employee. That doesn't mean internal complaints are useless. They are often legally necessary, and if internal processes haven't resolved the situation, or if the retaliation is severe enough that you don't want to wait, your primary external option under federal law is filing a charge with the Equal Employment Opportunity Commission, the EEOC. The EEOC is the federal agency that enforces the ADA, Title VII, and other employment discrimination laws. Filing an EEOC charge is a required step before you can sue an employer for ADA violations in federal court. Stat callout: 180/300 days. File your EEOC charge within 180 days of the act, or 300 days if a state agency also enforces the law. Confirmed current as of 2026, EEOC.gov. Lower third, EEOC charge deadlines. Deadlines matter enormously here. In most cases, you have 180 days from the date of the discriminatory or retaliatory act to file an EEOC charge. In states that have their own employment discrimination laws and agencies, which is most states, that window extends to 300 days. Missing this deadline typically means losing your right to sue under federal law. Do not assume you have more time than you do. When you file an EEOC charge, the agency notifies your employer and begins an investigation. Mediation is a voluntary process where both parties try to reach a resolution with an EEOC mediator. It's confidential and significantly faster than a full investigation. If the EEOC finds reasonable cause to believe discrimination occurred, it will attempt to reach a settlement. If that fails, the EEOC may sue the employer on your behalf, or, more commonly, issue you a right to sue letter. Person submitting a form online. EEOC online charge portal on screen. You can file an EEOC charge online at eeoc.gov, by mail, or in person at a local EEOC office. You do not need a lawyer to file, but consulting with an employment attorney before filing is worth doing if you can, because the way you frame the charge can matter. Updated. In addition to the EEOC, many states have their own civil rights agencies. In California, that agency is now the California Civil Rights Department, CRD, formerly DFEH, renamed July 2022, at calcivilrights.ca.gov. In New York, it's the New York State Division of Human Rights. State laws sometimes provide broader protections than federal law. An employment attorney in your state can advise you. Filing an EEOC charge is itself a protected activity. Document everything that happens after you file, just as you documented what happened before. The most important thing you can do while still employed is to continue performing your job to the best of your documented ability. Because here's what employers do when they're facing a retaliation claim. They look for performance issues they can point to. Show up, meet deadlines, communicate clearly, respond to everything in writing when you can. Create your own record of your work that exists independently of your employer's assessment of it. Be careful about what you say and to whom. Colleagues can be asked by HR what you've said. Conversations that you thought were private can become part of an investigation. Keep your circle of trust outside the workplace. A trusted friend, a family member, your attorney. Consulting an employment attorney is not the same as suing your employer. An initial consultation, which is free at most employment law firms, which work on contingency, can help you understand your situation, assess your documentation, identify your options, and make informed decisions about next steps. You can talk to a lawyer and then decide to wait. If you are pressured to resign, do not sign anything before consulting with an attorney. Severance agreements almost always include a release of claims, meaning you agree not to sue the employer in exchange for the severance payment. Give yourself the time and information to know what you're signing away before you sign it. Practical tip box. Free legal resources. The EEOC, eeoc.gov, your state's protection and advocacy organization, acl.gov, Disability Rights Advocates, drlegal.org. Many employment attorneys offer free initial consultations and work on contingency. Person walking out of an office building into daylight. Retaliation happens because employers calculate that most people won't know their rights, won't document what occurred, and won't take action. The calculation is correct often enough that it continues. You're harder to retaliate against successfully when you know the law, when you've documented your record, and when you understand your options. That's not a guarantee of any particular outcome, but it changes the calculation. The resources that matter here. The EEOC at eeoc.gov, your state civil rights agency, your state's protection and advocacy organization at acl.gov, and an employment attorney for a free initial consultation. We'll link all of the key resources at disability.co/episode 12.